Namaskar. Good morning, brothers and sisters, ladies and gentlemen, students and scholars, teachers, trainers, professors, professionals, listener, learners. I welcome all respected doctors and directors. I welcome all adorable ministers and managers. I welcome all honorable advocates, advertisers, administrators, advisors. I welcome scientists, doctors, engineers, artists, especially I welcome the most honorable President Mr. Modi ji. Dr. Rakesh from USA, heartily cordially welcome. It is really nice time, nice place, nice action today that we are appreciating, admiring, praising our holy Indian constitutional, cultural, spiritual identities in the form of unity and diversity. What are the general principles of law recognized by civilized states? Let us go through today para 1C of Article 38 of the Statute of International Court of Justice is general principle of law recognized by civilized states as the third source of international law. In the modern period, it has become an important source. It constitutes an important landmark in the history of international law, inasmuch as the state parties to the statute did expressly recognize the existence of third source of international law, independent of custom or treaty. This source helps international law to adapt itself in accordance with the changing times and circumstances. As pointed out by G. Van Leyen, renowned author of international law, two views are prevalent about the phrase general principles of law, recognized by civilized nations. According to one view, the phrase includes such general principles such as both sides of a dispute should be given a fair hearing and no one can sit in judgment in his own case, which are found in domestic jurisprudence and can be applied to international legal questions. The other view regards the other views the other view regards the phrase as linked to national law as interpreted during recent centuries in the Western world. According to this view, general principle of law recognized by civilized nation have emerged as a result of transformation of broad universal principles of law applicable to all the mankind into specific rules of international. However, law of natural represents at best a vague and ill-defined source of international law. The former or the first view about the general principles of law is generally prevalent today by general principles of law recognized by civilized states remain those principles which have been recognized by almost all the states owing to the gaps in international law. It was felt that the competence of the court could not be confined to making judgments according to positive international law. That is, according to custom and conventions, but on the other hand, it was not designed to give free rein to the lawmaking activity of the court, and the court had to content itself with applying principles of law which could be established as common to the municipal law of all civilized nations and were therefore positive law. Though not positive international law, in the Lotus case, the Permanent Court of International Justice also observed the court considers that the words principles of international law as ordinary used can only mean international law as it is applied between nations belonging to the community of states. खास खबर देश बापू का कर रहा नमन आसाम दौरे पर गृह मंत्री अमित शाह राज्य विधानसभा के नए भवन की रखेंगे आधारशिला पार्टी पदाधिकारियों के साथ करेंगे बैठक ऑस्ट्रेलियन ओपन आज से पुरुष एकल सेमीफाइनल मुकाबले पीएम मोदी ने पीटी उषा से की बात पीएम मोदी ने पीटी उषा से की बात पीटी उषा के पति के निधन पर जताया शोक पीएम मोदी ने पीटी उषा से की बात नृत्य और उत्सव का संगम उज्जैन का महाकाल महोत्सव पीटी उषा के पति के निधन पर जताया शोक आज भारत अरब वरिष्ठ अधिकारियों की होगी बैठक आज भारत अरब वरिष्ठ अधिकारियों की होगी बैठक पीटी उषा के पति के निधन पर जताया शोक। गृह मंत्री अमित शाह का असम दौरा। It may be noted here that a principle of law, which is recognized by domestic law of a large number of states, does not automatically become a principle of international law. It becomes a principle of international law only when it is recognized as such by the world. Thus, Letterpatch has therefore rightly remarked that the main function of the general principles of law has been that of a safety valve to be kept in reserve rather than a source of frequent application. The word court resorts to the application of this source only when, in a case before it, there is neither an international convention nor a custom in respect of the dispute involved. Thus, Article 38, paragraph 1c of the Statute of the International Court of Justice places on record one of the main sources of the rules of public international law. Indeed, it describes the inexhaustible reservoir of legal principles from which the tribunals can enrich and develop public international law. By general principles of law, we mean those rules or standards which we find repeated in much the same form in the developed systems of law, either because they have a common origin as in Roman law or because they express a necessary response to certain basic needs of human association. Examples are the rule of pacta servanda, that contracts must be kept, the principle that reparation must be made for damage caused by fault, the right of self-defense for the individual against attack on his person or family and the community against clear and present danger, and the principle that no man may be a judge in his own case, no man may be a judge in his own cause, and that he who has to judge must hear both the sides. Further, we must emphasize that general principles of law and systems of law or those derived from them but can be traced also in Islamic law. Customary laws in Africa, religious law in India, and traditional laws in China and Japan. The general principle of law. Case of diversion of water from use, the permanent part of international justice applied res judicata, and in this case the court applied the general principles of subrogation. In this case, frontier dispute Burkina Faso versus Mali. In 1980s, Burkina Faso and Mali entered into an agreement to refer their frontier dispute to the International Court of Justice. During the agreement consisting at this time of two opposed world systems. There are no such general principles except those established by international agreement as part of international law. This view does not seem to be correct because If this view is accepted, the international part will have no right to if this view is accepted, the international part will have no right to in respect of recognition of general principle. With the breaking up of Soviet Union and end of communism in Russia, Cold War had ceased and hence this view has lost its importance. Inclusion in Article 38 1C of the Statute of International Court of Justice shows clearly that the positivist doctrine, according to that, the positivist doctrine, according to which international law is a body of rules on which the states have given consent, has been the death knell of positivism in as much as it explicitly rejects the broad positivist view that custom is dimension of international law and the creative have been ensured. Indeed, it enables rules of law to exist which can fill the gaps or weaknesses in the law. It may operate to modify their application. This is the avoided period International Court of Justice is the main international judicial tribunal. It was Article 59 of the Statute of the International Court of Justice. The court does not deviate from its earlier decisions and it changes the doctrine of precedent